Hello, everyone, and welcome to Uncivil Law. Today, we are talking about race-based discrimination at colleges in the case of Students for Fair Admissions versus Harvard College. This has been a case that was basically set up and created from square one to go to the U.S. Supreme Court. So the trial court wrote a very lengthy opinion. The Court of Appeals wrote a very lengthy opinion because this case was created, manufactured, specifically to go to the U.S. Supreme Court. So, that sometimes happens where those kinds of things happen, and that is this case. So whether or not the U.S. Supreme Court will take certiorari or not, who knows? But this case was designed with that in mind, and the Court of Appeals has spoken. So in this case, Harvard may or may not be discriminating on the basis of race. So we're going to read a little bit about what they did or what they didn't do, at least according to the Court of Appeals, and try to figure out what's going on. Let's get started with this. The plaintiffs assert that Harvard fails to meet the Supreme Court standards for the use of race in admissions were asserted to be justified by diversity in the following ways. That Harvard allegedly engages in race-based balancing of undergraduate classes, that it impermissibly uses race as more than a plus factor in an admission decision, it considers race in the process despite the existence of workable race-neutral alternatives, and it intentionally discriminates against Asian American applicants to Harvard College. The plaintiffs seek a declaratory judgment and interjunctive relief, attorney's fees, and costs. After a 15-day bench trial, of which 30 witnesses testified, the district court issued a 130-page opinion with findings of fact and conclusions of law. So yeah, this was done very deliberately and very slowly because everyone kind of knows where this is going. So we had 130 pages from the district court trying to explain in very copious details exactly what happened to make sure the record is super clean. It's to make sure because everyone kind of knows where this is going. And the Court of Appeals wrote 101 pages. So it's not exactly like record breaking, but it is a lot of verbiage because everyone kind of knows or at least expects where this is going. So 130 pages from the district court, 104 pages from the Court of Appeals, because everyone's making sure that things are clear if it's going to the U.S. Supreme Court, which everyone expects. Because Harvard accepts federal funds, it is subject to Title VI. 42 U.S.C. 2000D. No person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Title VI's protections are coextensive with the Equal Protection Clause of the 14th Amendment. So even though Harvard is, of course, a private school, it nevertheless is subject to federal law in this context because it accepts federal funds, including scholarship monies. So basically every college is going to be subject to this clause. And so they can't discriminate on the basis of race unless they have really good reasons. And so we're trying to figuring out whether or not they have really good reasons. When Title VI applies, a university is prohibited from considering race in its admission process unless the admission process can withstand strict scrutiny, which is usually our highest level of constitutional review. Citing the leading case on this, Fisher. Well, there's Fisher 1 and Fisher 2. Those are definitely the leading cases on this issue right now, so those citations will come up a lot. Harvard admits that it considers race in its admissions process and at times provide tips to applicants based on that race. Strict scrutiny applies regardless of racial animus. Strict scrutiny requires the university use of race must further a compelling interest. So it doesn't matter if Harvard has impure motives or mean motives. It doesn't even matter if they're trying to do things for good reasons. So their reasons, their moral reasons or their motive is not relevant. So if they hate one race or they love one race, it doesn't matter. We're going to look at this objectively. We're just going to look to, do you have a compelling interest and are you doing it in a narrowly tailored way? So let's do that. When asserting a university's interest in student body diversity, it has long been the law that a school bears the burden to prove that the reasons for any racial classification are clearly identified and unquestionably legitimate. A university's goals must be sufficiently measurable to permit judicial scrutiny of the policies adopted to reach them. The plaintiffs' appellants challenge us that does not contest that Harvard has a compelling interest. So they basically admit to the first half of the equation. They say there is a compelling interest. Nonetheless, Supreme Court precedent compels us to assess where the interest in diversity is both clearly identified, definite, and precise. So I kind of like this, and again shows that the court knows exactly where this is going. So they basically concede to the first part of the argument. But even though they conceded, the court is going to analyze it anyway because they don't want to have to deal with any remand issues. So they're just going to, even though they conceded, we're just going to independently look and try to figure out whether it's compelling anyway. So good work from the appellate court because, just trying to cover all their bases. So the Court of Appeals then says the Fisher 2 majority, referring to the Supreme Court here, held that the University of Texas's interest in diversity was definite and precise when it identified the educational values it sought to realize through its race-conscious admission program. So Fisher 2 was the last big case on this, and it was pretty controversial at the time, and this is basically trying to undo Fisher. These values included promoting cross-racial understanding, breaking down racial stereotypes, fostering a robust exchange of ideas, cultivating a set of leaders with legitimacy in the eyes of citizens, exposing them to different cultures, and preparing them for challenges of an increasingly diverse workforce. The Fisher 2 majority also held the record evidence from the admissions office relating to that same explanation for the university's use of race further supported the precision and particularity of its program. Turning to the present case, Harvard has identified specific, measurable goals it seeks to achieve by considering race in admissions. These goals are more precise and open to judicial scrutiny than the ones articulated by the University of Texas and approved by the Fisher 2 majority. So the Court of Appeals here is saying that the Harvard has gone farther in trying to justify its reasons than the University of Texas did. The implication being that if the less precise reasons of Texas are legitimate, then surely the more precise reasons of Harvard must also be legitimate because they try to, in even more detail, trying to establish what they're trying to do. The following specific goals were identified by Harvard: training future leaders in public and private sectors as Harvard mission statement requires, equipping Harvard graduates and Harvard itself to adapt to increasingly pluralistic societies, better educating Harvard students through diversity, and producing new knowledge stemming from diverse outlooks. These goals make it clear that Harvard's interest in diversity is not an interest in simple ethnic diversity, in which a specified percentage of the student body is, in effect, guaranteed to be members of selected ethnic groups, but a far broader range of qualifications and characteristics of which racial or ethnic origin is but a single, though important element. So here they are trying to say that they are adopting as part of a holistic approach. So whether or not you buy that or buy any of this is a whole other set of problems. But they are saying, look, we're looking just race as one of many factors of diversity. We're interested in diversity in many different kinds of diversity. And race is just one of those diversities that we look at. And we're trying to maintain a diverse outlook to bring diverse perspectives for a diverse and pluralistic environment. So whether or not you buy that, that's what Harvard says they're trying to do. And the Court of Appeals says that's more precise than what Texas said. So it must be legitimate if Texas is legitimate, which, as a logical statement, does flow. Having addressed the compelling interest aspect of this and finding it to meet the test set out, the court now next needs to turn to whether or not it's narrowly tailored. So has what Harvard done been narrowly tailored to their compelling interest? Let's discuss. Narrow tailoring requires that the means chosen to accomplish the university's goals must be specifically and narrowly tailored to accomplish that particular purpose. Under the Supreme Court precedent, a university admission program cannot be narrowly tailored if it involves race-based balancing or quotas, from Fisher 1, or uses race as a mechanical plus factor, also from Fisher 1, or is used despite workable race-neutral alternatives, see Fisher 2. All right, so we'll stay on the screen for just a moment so we can discuss the present. So we see Fisher 1 and Fisher 2. So this is the state of the law as it exists right now. So Fisher 1 and Fisher 2. So it's if it involves race balancing or quotas. So if we need a specific minimum number or a specific percentage, or we're interested in maintaining a specific balancing, we can't do that. We use race as a mechanical plus factor. So basically that would be, if you're of this particular race, we just give you a buy of a particular number, whatever it is. So you need a score of whatever to get into Harvard, and because you're black, we give you plus whatever. Or because you're Asian, we give you minus whatever. That would be mechanical. We can't do that. Or if you're using it despite race-neutral alternatives. So if there's any race-neutral alternative that will work, then we have to do those. Those are the things we are not permitted to do, at least according to the state laws that exist right now. So having set up the legal standards from the prior cases of Fisher, we now need to turn to some of the specific facts and try to figure out whether or not the facts suggest one thing or another, at least as to the case law as it currently exists. So let's do that. Considering the broader context, the share of admitted Asian American applicants for the classes of 1980 to 2019 has increased from a low of 3.4% in 1980 to a high of 20.6% in 2019. The share of Asian American applicants has ranged from a low of 4.1% in 1980 to a high of 22.5% in 2014 over the same period. So the first thing the court is noting is that these numbers are kind of correlated, right? So in 1980, there was 3.4% Asian admitted, but there was only 4.1% Asian applicants. Those are pretty close. And then the high of 20.6 in 2019, but the high was 22.5 in 2014, different years. But again, those numbers are kind of close. The level of variation in the share of admitted Asian applicants is inconsistent with a quota, or as a fact of a share of admitted co-varies almost perfectly with the share of applicants. So the court says, well, it can't be based on a quota and it can't be based on a balancing, because if you look at these percentages and you look at the percentage of people who applied and you look at the percentage of people applicated, they're pretty well correlated. So it doesn't seem like there's a quota. It doesn't seem like there's a balancing. It seems like they're admitting Asians roughly to the percentage that they're applying. Okay. The plaintiff's contention that Harvard elevates racial diversity above other types of diversity is not supported by the evidence. Harvard has demonstrated that it values all types of diversity, not just racial diversity. Again, whether or not you believe that, that's what the Court of Appeals thinks. Harvard's use of race in admissions is contextual and does not consider race exclusively. Harvard's process does not weigh race so heavily that it becomes mechanical or decisive in practice. Harvard's undergrad admission programs considers race as part of a holistic overall review. The use of this was previously praised by the Supreme Court as a way of considering race in a non-mechanical way, so it's only one of many factors. The plaintiffs argue that Harvard's use of race fails the narrow tailored process of strict scrutiny because Harvard has disregarded race-neutral ways of accomplishing its goals. So they say, well, all that might be true or might not, but also there were race-neutral alternatives that you didn't do. And you have to do that if you can. So is that true? The Supreme Court has distinguished conceivable alternatives from workable alternatives, requiring only to use those that are workable. So you only have to do those that can actually work. Harvard has met its burden, including through a Smith report, to show that it has carefully considered all the available alternatives. It has concluded that those alternatives are not workable and would undercut its educational objectives. Narrow tailoring does not require a university to choose between maintaining a reputation for excellence or fulfilling a commitment to providing educational opportunities to members of all racial groups. So the Court of Appeals at least thinks that Harvard has demonstrated through its reports that it has considered other alternatives and tried to justify why those alternatives would not work for Harvard. And so it says, well, yeah, you've looked at all the alternatives and none of them would work for your goals. And therefore, this is the only alternative left. So therefore, there are no workable alternatives. So you met your goals. The plaintiff's final claim is that Harvard's admissions policy intentionally discriminates against Asian Americans. To make out a prima facie case of intentional discrimination on the basis of race under Title VI, a plaintiff must show the defendant treated members of one race differently and less favorably than members of another race, and that the defendant did so with racially discriminatory purposes. The Supreme Court precedent makes it clear that the fact that Harvard's admission process is subjective is insufficient to overcome other evidence in the record that Harvard is not biased against Asian Americans and does not stereotype them. So what they're saying here is that Harvard does do some subjective stuff. It's not mere mechanical stuff. It's not merely, what is your GPA? What is your class rank? What was your SAT score? It's not just mechanical. There is a subjective element at the end of the day. Things like personality, fit. So there is subjective elements, but merely because it's subjective does not in and of itself prove bias. There is no requirement that universities use entirely objective criteria when considering race to admit applicants. So they can consider subjective factors. They just can't discriminate on the basis of race. The nature of Harvard's admission process, as the district court recognized, offsets any risk of bias. So they're saying that their process prevents the bias. How? An applicant must secure a majority of votes at a full-body admissions committee meeting with 40 admission officers to be admitted to Harvard, which mitigates risk that any one individual officer's bias or stereotyping would affect the admissions process. As to the plaintiff's second argument, while the share of Asian American applicants admitted to Harvard did increase from 19.1% for the class of 2018 to 20.6% for the class of 2019 after this lawsuit is filed, the argument ignores the broader context. So the plaintiff said, well, they've only increased admissions after the lawsuit. And the court says, no, you're looking at the wrong numbers. Asian Americans constitute 20.3% of the admitted class of 2016, showing that 20.6% of the Asian American admits for the class was not anomalous. So, yeah, in 2016, they admitted to 20.3, so 20.6 wasn't some crazy anomaly. It's within their practice. Neither was the post-filing increase from 19.1%, or post-filing increase from 19.1% for the class of 2018 to 20.6% for the class of 2019. The share of Asian Americans similarly increased from 17.6% of the class in 2010 to 19.5% of the class for 2011, and from 19.3% 2015 to 20.3% for 2016, before this lawsuit was filed. Indeed, the number of Asian Americans admitted to Harvard has been steadily increasing for decades, along with the admissions profile as previously noted by the Court of Appeals. There is a clear and important distinction between race being correlated with personal ratings and race influencing those ratings. Race correlating with personal ratings means there is a statistical relationship between race and personal rating. Race influencing is a personal relationship, means that this is causal. It means that Harvard assigns applicants higher or lower personal skills because of their race. The distinction between correlation and causation is very important. So one of the factors here is that one of the things that Harvard does is they do these personal interviews where they interview the people who are coming into Harvard and they give them a score. And the allegation was that Asians on the whole are getting much lower scores than other applicants. And so what the court is pointing out here is that even though there might be a correlation, it doesn't necessarily mean it's caused by that. You have to show something else to show causation. If race is only correlated with the personal rating, excluding it from the regression model could make it appear as though Harvard discriminates when it does not. If race influences the personal rating, including it in the experts' regression models, could make it appear as if Harvard does not discriminate when it does. We repeat that the statistical models used by the district court using the personal rating did not show discrimination against Asian Americans. Rather, it shows that Asian Americans' identity has a statistically insignificant overall average marginal effect on admissions of a probability of 0.08%. That means on average, the model shows that Asian American students have a 0.8% or 0.08% chance lower of admission to Harvard than a similarly situated white student, and this effect is statistically insignificant, different from zero. So yeah, it's only 0.1%, and so when we account for everything, at least according to statistics, the way the district court did it, the bias is not actually reflected, at least as far as the Court of Appeals is concerned. Therefore, the district court did not err in finding that Harvard did not intentionally discriminate against Asian Americans. Harvard has an ongoing obligation to engage in consistent deliberation and continued reflection regarding its admission policy. The issue before us is whether Harvard's limited use of race in its admission process in order to achieve the diversity in its period in question is consistent with the requirements of Supreme Court precedent, and there was no error from the district court, therefore affirmed. Thus, that brings us to the end of the case of Students for Fair Admissions versus Harvard College. So, as everyone is predicting, this is very likely to go to the U.S. Supreme Court. Will the U.S. Supreme Court take cert or not? Who knows? But the Court of Appeals for the First Circuit knows that notices the district court issued a 130-page opinion trying to explain all the facts in copious detail. And this opinion was 104 pages. So we skipped a lot of it in the interest of time, trying to get to the principal legal issues. So the only thing left to do for the Supreme Court would be to overturn its precedent, which is, of course, something it can do. But the Court of Appeals is saying, well, look, they're actually not discriminating against Asians. When you factor everything in, the statistics don't show the discrimination, so it's all an illusion. So whether or not any of that's true, the Court of Appeals seems to think it is, and the Supreme Court's unlikely to reverse on that basis. They're unlikely to disagree with those kind of findings and say, no, actually, that's not what the district court said. That's unlikely. The only realistic chance is the Supreme Court just overrules Fisher completely. And maybe they do overrule Fisher and say race is not a valid factor in discrimination. But the Court of Appeals has certainly tried to give its best effort for why it should be upheld. So what will the Supreme Court do? Will they take cert? Will they overrule Fisher? Who knows? But we will find out. But at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.